everyone. Thank you so much for joining us. We're a couple minutes into the lunch hour. My name is Marissa Choi. I'm an attorney with Southern California Edison, and I'm a member of the executive committee for the Environmental Law Section at the California Lawyers Association. So we are thrilled to kick off our 2023 Intro to Environmental Law series. We've done this the past few summers, and the idea is that these are kind of entry-level nuts and bolts 101 totally free Zoom sessions, usually during the lunch hour. We've done a bunch of different environmental law topics: water law, air quality, CEQA, climate change. And you can see we're starting with forestry law this summer. Next month, we'll have a session on drinking water and PFAS, a hot topic these days. August, we'll do a session on land use. And these are all to kind of give people background and a taster of the field leading up to our annual environmental law conference at Yosemite, which happens every October. So please stay tuned. And we are partnering next with a few different organizations. So as I mentioned, California Lawyers Association is the umbrella organization here in the state, grew out of the state bar, but it's a voluntary bar association, has about 16 or 18 different sections. So this is co-sponsored by the Environmental Law Section, as well as the New Lawyers Section. So environmental law, we cover, environmental, natural resources, land use, energy, a whole bunch of different areas. The New Lawyers Section actually has folks from different practice areas, but it represents all California lawyers in their first 8 years of practice. So if there are law students on the line or people studying, about to take the bar, once you pass and you, get your bar number, you'll be automatically enrolled, and there are a lot of great resources. Next slide. So also new for this session only, a couple of our panelists are affiliated with the American Bar Association. So California Lawyers Association is here in the state. Nationally, we've got the American Bar Association. They too have a bunch of different sections covering different practice areas. So the section of Environment, Energy, and Resources has a Forest Resources Committee. Specifically, they've got a bunch of different committees. And so that's a great group of lawyers who work in this area, and they're happy to partner with us and help promote this knowledge transfer. Next slide. All right, so just gonna give a quick intro to who you'll be hearing from today. We have an hour and a half. Each of us, I'll do the intros and let everyone kind of go through. People are covering different practice areas: state law, federal law, as well as the private practice perspective. And we'll leave time at the end for Q&A. You'll also get to hear a little bit about what it's like day in the life, the type of work that each of these practitioners does. So again, I'm Marissa. I'm an attorney in-house at Southern California Edison. We do a lot of work with trees and forests and agencies. My background is as an environmental and energy attorney. Our first speaker is Susan Jane Brown, who is at Silvix Resources. She's a principal, and she was formerly with the Western Environmental Law Center. She does a lot of work up in the Pacific Northwest. And she also teaches at Lewis and Clark Law School in Portland. She's a former co-chair of the National Advisory Committee for Implementation of National Forest System Land Management Planning Rules. She also serves on the Federal Advisory Committee for the Collaborative Forest Landscape Restoration Program. And as I mentioned, she's heavily engaged in forest restoration in the Upper John Day Basin in Eastern Oregon. Our next speaker is Toby McCart, who is the Assistant Chief Counsel at CAL FIRE. And that stands for the California Department of Forestry and Fire Protection, CAL FIRE. So in his role, he supervises all CAL FIRE attorneys working on environmental and natural resources law, including the attorney assigned to the forest practice program. Prior to becoming the first assistant chief counsel, he was the first attorney who was dedicated solely to forest practice. And he has over 10 years experience providing advice and counsel related to private timber harvesting. He's argued 50 forest practice enforcement cases. And this is a fun fact, he is a graduate of Lewis and Clark Law School, and he actually took Susan Jane Brown's Forest Law and Policy course. And then finally, providing some of the private practice perspective, we have Liz Esposito, who is a shareholder with Brownstein, Hyatt, Farber, and Schreck. She's based in Sacramento. She's a natural resources attorney specializing in forestry, NEPA, so National Environmental Policy Act, and CEQA, the California Environmental Quality Act, and water resources issues. She manages the environmental analysis process for complex natural resources projects and develops tailored strategies to assist clients in navigating environmental permitting. She previously worked for the Forest Service and for the USDA, U.S. Department of Agriculture Office of General Counsel, where she advised the Forest Service on natural resources and land management issues. So with that, I will ask to advance the slides. And our plan for the day is that we'll let each of the speakers kind of go over some of the background, the legal background, to give everyone a framework of the federal forest law, the state forest law that applies here in California, and private practice. I think each of our speakers is going to walk through some of their work examples from their day-to-day practice. And they'll also share some opportunities and resources that folks on the call can look into if you are interested in getting involved in this area. And then I will come back at the end and just share a few more ways to get involved, and we'll save some time for questions at the end. All righty. With that, I will hand it over to Susan Jane.
Great. Thanks, Marissa. Appreciate it. Welcome everybody out there in Zoom land. Thanks for joining us on your lunch hour to talk a little bit about Forestry 101 in California. I'm going to focus on federal forest law, which is my area of practice, and talk a little bit about the kind of work that I do and how you might get involved if you are interested in the federal level of practice. Just a little bit of information about me. I graduated from law school at Lewis and Clark in 2000. So I've been practicing for 23 years here in the Pacific Northwest. Until recently, I was with the Western Environmental Law Center, where I'd been for 14 years. And I recently started my own practice called Silvix Resources, which is a nonprofit environmental law firm focused on federal forest law, policy, and collaboration issues. So I am a practitioner, and I spend a lot of time, in fact, all of my time, focused on federal forest law issues. So that's what I wanted to talk to you a little bit about today. As Marissa mentioned, I also teach forest law and policy to upper division law students, like Toby once was, at Lewis and Clark Law School. And so I have a lot of experience working with students who are interested in this area of law. So if you have questions at the end that you have particular questions about how to enter this practice or anything like that, I'm happy to take those either at the end or offline once we finish up. So a couple of procedural and substantive basics about federal forest law. First, the general practice area pertains to the management of federal forest lands, and the federal government manages a lot of forest land, a lot of public land across the United States, both in the lower 48 and in Alaska, and not in Hawaii yet, but in Puerto Rico, where the United States Forest Service has a national forest there called the El Yunque that they manage. So both domestic and foreign, if you will. But there are a variety of federal lands that have forests on them that show up in my practice area. So the national forests, which are managed by the United States Forest Service, other public lands that are managed by the Bureau of Land Management, national parks, which are managed by the Park Service, wildlife refuges, which are managed by the National Fish and Wildlife Service. And then there are also Department of Defense lands that are managed by the DoD. All of those are public lands, many of which have forests on them. And so federal forest issues can touch on various lands that are managed by different federal agencies in different federal departments. So there's a lot of jurisdictional issues out there in terms of who manages what. All of those lands also have different federal environmental laws that apply to them. So I definitely deal with a lot of alphabet soup, like I listed there on the slide. So the National Forest Management Act applies to national forests, which are managed by the Forest Service. The National Environmental Policy Act is a broad environmental law that applies to all federal agency actions and decisions, including those managed or those decisions made by the federal land management agencies. The Multiple Use Sustained Yield Act applies to the Bureau of Land Management when they manage their public lands, as well as the United States Forest Service. So many of our federal public lands are multiple use lands like national forests or BLM lands. They are managed for multiple uses, and those multiple uses come from the Multiple Use Sustained Yield Act. Other lands like national wildlife refuges, for example, are managed under dominant use statutes that are specific to those refuges. And typically the dominant uses of the wildlife refuges are for wildlife conservation. And each of those refuges have their own statute that was enacted by Congress. Also deal with the Federal Land Policy and Management Act that applies to the Bureau of Land Management, also multiple use dominant statute. So there's lots of statutes that are involved in federal forest law that come up on a regular basis, some of which are specific to the agency and the lands that they manage. Some are applicable to all federal agencies and decisions like NEPA, for example. Litigation in this space, and I am a litigator, I represent conservation organizations and allied individuals and tribes in federal court. That litigation usually involves challenges to federal agency actions and decisions affecting those federal forest lands. So I'm in court representing conservation organizations that don't like a decision that the Forest Service or the Bureau of Land Management may have made. And again, I represent conservation organizations. I'm on the plaintiff side, and I'll talk a little bit more about that. But government attorneys, for example, obviously represent the government in defending actions or sometimes bringing enforcement actions as well. But typically, I am representing conservation organizations challenging federal agency decisions and actions. Also, usually in this space, in the federal forest law space, we are looking at administrative record review cases as opposed to going to trial. So when the federal government makes a decision affecting federal public lands, the decision is encompassed in what's called the administrative record. And some of you may be familiar with that from some of your experience. The administrative record is basically, if it is a virtual thing, although it is now reduced to digital information, but you can think about it as a filing cabinet. So anytime that the agency makes a particular decision, it will have to support that decision with underlying analysis, emails back and forth between specialists, decisions that come from the national office down to the local office, conversations or communications with the public, regulated industries, tribes, governments, that sort of thing. All of those communications around one specific agency decision or action comprises the administrative record. So when I challenge a Forest Service decision, for example, in federal court, I will receive the administrative record, which is all of those communications, all of that supporting information that went into supporting the agency's decision. And when I go to court, the court is only going to look at that administrative record in adjudicating my claim. So there aren't things typically like discovery, for example. So in civil practice or even in criminal practice outside of environmental law, typically claims are resolved based on a trial where you have either a judge or a jury who oversees that trial. Both sides put forward evidence, and the decision maker, whether that's the judge or the jury, will evaluate that information and come to a decision. That's not how it works in federal forest law. Instead, we are limited just to the administrative record. So there is no factual discovery, and everything is based on the facts that are in that administrative record. So what we fight a lot about is those facts and what those facts actually mean, and whether or not the agency has met their legal obligations based on the content of that administrative record. So it's a really different approach and process in federal environmental law, and particularly forest law, than it is in private or non-federal practice, where you are generally going through a trial. So we don't have trials in federal forest law. Very, very rarely will you have one of those. In 23 years of practice, I've never had one. So they are a rare beast where you might have a trial, but generally issues relating to federal forest law are resolved based on the administrative record. The other thing that I wanted to flag is the role of science. Science we often fight about in court on federal forest law issues, and whether or not the agency considered the best available science, whether there is competing science that the agency should have considered but didn't, and kind of where science lands in the decision-making process. So the role of science is usually something that comes up in federal forest litigation, much more so than it might in other contexts. Next slide, please. So a couple of examples of how one might practice federal forest law. And I take this from my own practice, and everyone's practice might be a little bit different, but this is kind of how my practice looks. First of all, in federal forest law more broadly, you can be an attorney and represent a party on either side of the V. So you can be a plaintiff side lawyer like I am, where I represent organizations, conservation organizations, individuals, tribes. You can also work on the defendant side. You can represent the federal government or regulated industry. You can also represent interveners who may be regulated industry like the timber industry that may want to intervene on behalf of the government to defend a decision that my plaintiffs, environmental groups, don't like. So as a practitioner in federal forest law arena, you can pick a side. You can be a plaintiff side, you can be a defendant side attorney, you can be intervener side. Obviously, you've got to be consistent. You can't work both sides of the V and maintain your ethical obligations. But in terms of being a practitioner in this space, you can be on all sides of the V. And we'll hear a little bit from Liz and Toby about how that shows up in their practice as well. I do different types of legal work as a lawyer, as a barred attorney. Obviously, litigation is one of those things where I'm in court representing plaintiff side conservation organizations against typically the federal government. So that's litigation. Most of that kind of work for me is summary judgment motions, but also a substantial part of my work involves moving for emergency injunctive relief. So seeking a temporary restraining order or a preliminary injunction from the court to stop a project from being implemented out in the field. So usually my practice is summary judgment and immediate relief efforts, so emergency injunctive relief. You can also, as an attorney in this space, work in the policy arena, which is also a part of my practice. In that way, I use my legal expertise and training to advocate for policies that I think, or my clients believe, are in the best interests of their members and of the environment. So what that looks like is I spend time with allied conservation organizations working on responding to federal proposed legislation, or working with decision makers to advance legislation that we support. So for example, right now in Congress, there are a lot of proposals around wildfire risk mitigation. Some of those policies or proposed legislation are things that I and my clients support. Some of those things are proposals that we do not support. So we will spend time lobbying, which you do need to be a registered lobbyist for that kind of work, but we lobby for or against legislation. We also work with the media or other decision makers who may be supportive or opposing particular pieces of legislation. That work can happen at the federal level on federal pieces of legislation. It can also happen at the state level So in the state legislature in California, for example, there's a lot of fire policy being debated there as well. And engaging at the state or federal level on policy initiatives is something that I do and that you can do too as an attorney, because your legal education and background and experience with the law is relevant to decision makers who often don't have access or ready access to that kind of information. So you can be a source of information in that way. I also participate in federal forest collaborative work. That's entirely different than litigation or policy. It's non-legal, non-litigation, but it does utilize my expertise in federal forest law to help stakeholders and partners understand the legal framework in which we are operating when we're talking about the need to restore large landscapes. So that collaborative enterprise is very much person-based. It's slow work. It's about building relationships and working with others to move restoration work forward on the ground. So it's very much place-based, very much action-oriented. And then finally, government work. You can work for the federal government. You can work for state agencies like Toby does. You can work for tribes. You can work for local governments who may have a stake or an interest in federal forest law. And so you can work that side of the equation as well. Next slide, please. Hopefully next slide. There we go. So there's a lot of opportunities to become engaged in federal forest law. A lot of issues are currently percolating in this field. Climate change is a huge issue. It's driving a lot of law and policy these days, and I predict that it will continue to do that and probably increasingly drive legal and policy decisions in this space. For example, I've been working on the infrastructure bill, which was enacted by Congress a couple of years ago, as well as the Inflation Reduction Act. Both of those pieces of legislation, I worked with congressional staff to draft some of those provisions that now became law. And so I've been engaged with other stakeholders in monitoring the implementation of those statutes. So when we set out priorities for where money and investment should go to reduce wildfire risk, is it actually going to those places? Is it not going to those places? If it's going to those places, great. Are we getting the results that we wanted? So there's a lot of work around the wildfire crisis strategy that the Forest Service has put forward around reducing the wildfire risk on federal public lands. There's also a lot of work and chatter today and around mature and old growth protection, both from the Bureau of Land Management and the Forest Service, stemming from President Biden's executive order that he issued on Earth Day a couple of years ago. So how is all of that showing up in the federal policy space, and what changes may need to happen in law in order to effectuate some of those changes? There's also a lot of work around federal forest law in terms of climate change, or excuse me, in terms of wildlife conservation. A lot of our wildlife are found in forests or depend on forests. And so even though you may be focused more on trees, for example, those trees are home to a number of wildlife species. So I often work with the Endangered Species Act in order to conserve wildlife that are dependent on forests that the Forest Service or the BLM may want to manage. So that issue, if you're a wildlife advocate, often shows up in forest law as well. And then finally, forest planning. Both the Forest Service and the BLM and other federal agencies are required by law to develop plans to manage their forest holdings. And forest planning is really where a lot of the substantive requirements to protect old forests or to conserve wildlife or to protect clean drinking water sources, for example, all of those issues show up in forest planning. And that is a complex legal issue and legal field. And it's also something where a lot of practitioners find a lot of opportunity to apply their skills for sure. Next slide, please. So in terms of resources, if you are interested in federal forest law, where you might be able to find out more information, first I suggest local non-governmental organizations. There are a lot of citizen groups out there that are concerned with federal forest management. Local organizations typically know more about what's going on locally than national organizations, but regional and national conservation organizations that are focused on federal forest issues are also great places to find information and also seek employment opportunities, because a lot of those groups need legal help, even if they don't have the capacity to hire an attorney as a litigator. They may have capacity to hire you to consult, for example. So a lot of opportunities with NGOs. The Public Interest Environmental Law Conference is a national conference. It's hosted by the University of Oregon in Eugene every March. It is a fantastic place to meet and greet people, to network, to find jobs or compatriots in this field. So I would highly recommend the Public Interest Environmental Law Conference if you are interested in getting plugged in. Federal land management agencies, they're on the other side of the V from me personally, but I work with the federal agencies quite a bit, and they are also hiring. You've probably heard recently that the Forest Service in particular is staffing up. So if you're interested in legal practice or natural resources, the federal land management agencies are a great place to become acquainted with and see if there are employment opportunities there. And then finally, environmental law programs. Recent graduates from law school, you may have attended law programs that do have a good environmental law program. And so those programs, even as a graduate, can be good resources for you beyond career services, just to find employment opportunities and take advantage of those things as you advance your career. So I will stop there and turn it over, I think, is Toby next? Or maybe it's Liz.
Toby.
All right, Toby, handing it off to you.
All right, thank you. So like Marissa said, my name is Steve McCart, and I do work for CAL FIRE. If you're anything like many a respondent in an administrative penalty case that I've worked, you're probably wondering what the guy from the fire department is doing here. Unfortunately, our rebranding as CAL FIRE was all too effective, in the sense that a lot of people have forgotten that we are the California Department of Forestry and Fire Protection. You know, we employ hundreds of registered professional foresters, other resource professionals do forestry. And it's just that those professionals also happen to be backed by one of the largest fire protection apparatuses in the world. So I'm a big history buff, but I'm going to do you a favor. I'm not going to take you back to 1885 like it says on our patch. I'm only going to take you back to 1945. Which was when the original Forest Practice Act was passed in the state of California. The original Forest Practice Act actually really empowered the timber industry itself to create its own regulations and basically regulate itself. In a case called Bayside Timber versus San Mateo County, 1971 case, an appeals court looked at that and said, no, you can't do that. You know, essentially that the basic principle is that, you know, no person can say on the judgment of themselves. No person gets to regulate their own industry. So the court did strike down the Forest Practice Act of 1945. And as a result, California was essentially left with no regulatory scheme governing logging on private lands. The industry magnanimously offered to continue to regulate itself according to the old rules. The legislature was naturally not so reassured by that. So as a result, within about 18 months of the Bayside Timber decision, Assembly Member Edwin Zeeberg and Senator John Nedgley primarily were the architects behind it, but they created the Forest Practice Act of 1973. And that is the act that remains in effect to this day. So one of the things that the Forest Practice Act does is it establishes a dual mandate. Specifically, the line from the statute is the goal of maximum sustained production of high quality timber products is achieved while giving consideration to values relating to sequestration of carbon dioxide, recreation, watershed, wildlife, range and forage, fisheries, regional economic vitality, employment, and aesthetic enjoyment. And this is really one of the things that makes me love my job. This dual mandate, you can see is intention. You know, the more you try to maximize the production of timber, the less you're giving consideration to the environmental resources of the forest. When I was in Susan Jane's class, we had a forester from one of the hyphenated national forests up in Oregon come in, and he said, you know, I know I'm doing my job right if everybody's mad at me. And immediately that absolutely appealed to me. Just sort of the nature of who I am, that thought of everybody being mad at me really appealed to me. And although I didn't really think of a career in forestry at the time, once I got on with CAL FIRE and started seeing the dynamic here, it really appealed to me. The Act also established a new state board of forestry and fire protection. So this board was authorized to promulgate regulations to implement the Forest Practice Act. And those regulations are commonly called the Forest Practice Rules. So what the Seeberg-Nedgley Forest Practice Act of 1973 does is it regulates the conduct of timber operations. Timber operations are defined in the Act as the cutting and or removal of timber or other solid wood forest products from timberlands for commercial purposes. There's a whole lot more of the definition, but those are the important elements of it. Timberlands, in turn, are defined as land that's not owned by the federal government, that's available for or capable of growing a crop of commercial species, which are defined by the Board of Forestry and Regulation. And commercial purposes is also an important element of that definition of timber operations. There's two commercial purposes that are identified in the Act. One is the obvious. You're cutting down those trees because you want to commercialize that timber. You want to sell that timber to a mill and make money off of that. But the other one that's a little less obvious and that gets a lot of private citizens, especially, in trouble, is the other commercial purpose is an intent to put timberland to another use besides growing timber. In other words, converting timberland to another use. Conversion, unfortunately, is a huge driver of our enforcement program because, again, a lot of people don't understand that, you know, just because you own the land, that doesn't mean you can slick off the forest to build your house on it, or increasingly to build your cannabis garden or what have you. At the heart of the Forest Practice Act and rules is the timber harvesting plan requirement. It's found in 4581 of the Public Resources Code, and it basically says if you're going to engage in timber operations, you have to have a timber harvesting plan. There are some other discretionary documents that you can get that sort of take the place of the timber harvesting plans. We'll talk about those later, but the THP, as it's called, is the primary document that we deal with as far as discretionary review. The Act and rules together establish a permitting system that puts CAL FIRE as the lead agency. We're the ones who have to exercise our discretion in approving or denying a plan. But we do that with the input of a lot of other responsible and trustee agencies, and including most especially the California Department of Fish and Wildlife, the Regional Water Quality Control Boards, and very importantly, but also less known, the California Geological Survey. Those are the three standard members of the review team that will always be present, always be asked for their input. Otherwise, we also have other stakeholders that are involved in that process. So we have our own archaeological and historical resource protection provisions that are separate from the CEQA system. That involves contacting Native American tribes to, if the operations could be taking place on their historical homelands, things like that. We have to notify utilities if there's potential impacts to utility lines. We have to notify all users of water from the same source as the operation, if the operation is trying to take water. So, and all neighbors. So those are generally the stakeholders and responsible and trustee agencies involved in the review process. The review process starts with a plan submitter submitting a timber harvesting plan to the department. It then undergoes an initial review by the department, and that's just a basic review to make sure that the timber harvesting plan facially complies with all of the Forest Practice Act rules, that it's in the right format, that it contains all the information it's supposed to contain, that all of the required notifications have been given, that sort of thing. If it doesn't make it to that review, it gets to the plan submitter with detailed description of what's wrong, what's deficient with the plan. If it does make it to that review, then it goes to a pre-harvest inspection, where all of the review team agencies will go out on an inspection of the land that's subject to potential operation, and will evaluate potential impacts of the timber operation. After that, the agencies will submit reports to CAL FIRE detailing their findings. Those reports will note any potential impacts and recommend potential mitigations to those impacts to render them less significant. And at that point, CAL FIRE has a duty to consider those recommendations, but it is still in CAL FIRE's discretion ultimately, what recommendations we implement and require of the plan submitter. This entire process is done publicly. The proposed harvest documents and all the review team reports are accessible to the public online. Susan Jane referred to the administrative record as being like a file cabinet. Unfortunately, some of CAL FIRE's systems are so outdated. The administrative review in some parts, or as to some parts, that is actually in a file cabinet, which is unfortunate, but we're trying to automate that more and give the public more access. So to that end, we've established a program called CalTrees, which allows anybody worldwide to go online and pull all of the harvest documents, all of the review team documents, recommendations, all of the public comments that have been submitted and all that. There is a public comment period. The length will depend on when the second review closes. It has to be a minimum of 30 days. And thereafter, if after the public comment period closes, there's a substantial amendment to the plan, then we would have to reopen it for further public comment. There are mandatory conditions under the Act and rules that require denial by the department. Some of them are pretty obvious, like the plan is just fundamentally deficient. The plan is obfuscates its impacts, what have you. But ultimately, one of the functions of the system is it's designed to get to yes. If CAL FIRE returns a plan, we have to give detailed reasons for why we're doing that. The way I always say it is, a forester could write on the back of the cocktail napkin, I want to harvest 100 acres in this area. And they could submit that cocktail napkin. And it would be up to us as a department to give them a detailed list of all the things they're missing in that cocktail napkin. So sometimes it's kind of frustrating because we feel like we're writing plans for the private sector. But again, it's all a function of the way the process is set up. Again, yes. That unless we get to an impasse where the plan submitter will not accept our recommendations and we're not willing to move forward without those being implemented, that's when we can deny a plan. If we do deny a plan, the plan submitter has the right to appeal to the Board of Forestry and Fire Protection, and also review team agencies, if we approve a plan, have the authority to appeal to the Board of Forestry and Fire Protection as well, and what's called a head of agency appeal. We don't see a lot of those because generally.
I'm sorry, Toby, you're coming in and out. Can you go closer to the microphone?
Yeah.
Thank you.
So, we, lost my train of thought here. But yeah, so other agencies have the right to file head of agency appeals, where they can go to the Board of Forestry and say, we think CAL FIRE is wrong for approving this plan. The Regional Water Quality Control Boards effectively have a veto over any plan. If they make a finding that a plan is inconsistent with the basin plan for the watershed, we have to deny the plan. We have no choice in that. So that's all in statute, and that's not in our discretion. So again, they effectively have a veto. Aside from timber harvesting plans, We have other discretionary permitting documents. The non-industrial timber management plan is for landowners who own less than 2,500 acres of timberland. And what that is it's a lifelong document. Unlike the harvesting plan, which is good for 5 years initially with up 2 1-year extensions, non-industrial timber management plan is perpetual. Once approved, the plan submitter only has to submit a notice of intent to operate under that NTMP in subsequent years. And as long as the notice of intent is consistent with the NTMP, then they're allowed to go harvesting and there's no discretionary process at that point. So the NTMP is scrutinized more heavily at the review process, but once it's approved.
Hey, Toby, we're having a little trouble hearing you. I think if you go to your, is it maybe your left? Hello, yeah, it's a little choppy.
Okay, sorry.
Oh, that's perfect, yeah.
All right.
Yeah.
So the NTMP gives you a lot more regulatory certainty in the future. You're not going back to that discretionary process. But again, it's a more rigorous discretionary process up front. We also have working forest management plans that are very similar to NTMPs. It's just for a larger area. I think it's 15,000 acres maximum. And then we have programmed timberland environmental impact reports, which are also perpetual documents. And those are available for ownership of any size. They're very rare. I think there's only 2 or 3 in the state of California. Aside from the discretionary documents, just as under CEQA, you have exemptions. You have exemptions under the Forest Practice Act and rules. Some of them are exemptions just from the timber harvesting plan requirement. So, for instance, the dead, dying, and disease exemption allows you to take up to 10% of the volume from timberland as long as those trees are dead, dying, or diseased. We have other ones for fuel reduction and things like that. We also have timberland conversion permit exemptions as well. Speaking of timberland conversion, that goes back to the second commercial purpose. If your purpose in harvesting the timber is to convert the timberland to another use, you not only need the timber harvesting plan, but you also need a timberland conversion permit. And that permit is we don't have a separate process for it. It goes through a regular CEQA process. So you're going to prepare either a mitigated neg deck or an EIR to support that. But ultimately, you still have to comply with the Act rules as that harvesting plan to implement the conversion. Finally, the Forest Practice Act and rules establish an enforcement mechanism. In the original Act, the only penalty was misdemeanor prosecution, maximum sentence of 6 months in jail, and a maximum fine of $500. In the late 90s, the legislature really started realizing that wasn't strong enough. And in some of the legislative reports, they point out that individual trees could be worth $50,000. So it almost makes business sense not to get the harvesting plan, just cut the tree down and sell it. So ultimately, the legislature added to the Act the administrative civil penalty provisions and civil penalty provisions. So in the administrative civil penalty realm, we file a complaint and proposed order with the respondent. They have 10 days to respond, saying whether they want to defend it or not. If they do, then it'll go before a hearing or go for a hearing before administrative law judge, the Office of Administrative Law. And then after that, the Board of Forestry will review the administrative law judge's decision and either accept it, reject it, or modify it. After that, the parties can go to Superior Court to challenge the Board of Forestry's decision. The other option is for CAL FIRE to approach the Attorney General's office and ask them to file a civil suit against the respondent. We tend not to do that because we prefer to do it in-house, and it's just cheaper and more effective to go the administrative civil penalty route. In either of the civil penalty systems, we can get up to $10,000 per violation. And a violation consists of something that's repeated on multiple days as multiple violations, and it's each distinct act. So we've gotten pretty good at stacking counts. We to get that penalty up to the point where somebody's going to take notice and change the behavior. Finally, I just wanted to mention our forest practice system is a certified regulatory program under CEQA. What that means is really not much at all. The certified regulatory programs are exempt from chapters 3 and 4 of CEQA and one section of CEQA relating to litigation. And chapter 3 is really just content of the EIR. So essentially what our certified regulatory program status means is we have to call our EIRs PhDs. Otherwise, we have to follow all of the substantive rules of CEQA. So essentially what that comes down to is forest practice action rules are the floor. You can't go below, you can't deviate from them, but it's not the ceiling. CEQA can always require more than what the forest practice action rules require. And in some situations, and I'll get to one later, the forest practice action rules might require more than what CEQA does. Next slide, please. So the kinds of work that I do, did before I promoted out of the position, we provide advice and counsel to the department on during the plan review process on compliance with the action rules, CEQA, and other laws, both in the plan review process and enforcement. An example of one of those situations that I worked on was a timber harvesting plan that was proposed in Del Norte County on a 20-acre parcel. The owner came from Oregon, where the state forestry laws are a little looser, and he wanted to clear cut 17 of those acres. And we only got a single public comment on this plan, but it was a juicy. It was about 3 sentences long, and in fact, there was a neighbor, and the neighbor said, "You guys are aware of that great blue heron refuge on that property, right?" Well, we were not. It was not disclosed in the plan, and we hadn't had a pre-harvest inspection yet, so nobody was aware of this. Our forester was livid, so she went out there and looked at the area and said that there's no way you could have missed this great blue heron rookery. CDFW had one of their scientists go out. They don't have the authority to go on their property, but they sat on a road looking towards the property, and they saw something like 8 great blue herons going into the stand and 12 coming out. So we're all a little bit upset about this. During the review process, we insisted on the buffer that's required by the Forest Practice Act and rules. And in this case, the rules really went beyond what the required, because the great blue heron is not endangered, it's not threatened, it's listed as a species of least concern by the IUCN. But under the Forest Practice Act rules, the Board of Forestry has designated it as sensitive species. And that's something that the Board of Forestry does for species that are particularly forest-oriented, that are impacted by forestry. So the great blue heron is one of them. And under the forest practice rules, you have to have a 300-foot buffer around the great blue heron rookery. No harvest within that buffer. And the 300 feet around that rookery was essentially going to take up about 6 acres of this 17-acre clear cut. So they did not want to agree to this. And sorry, my wife touched off. They sort of made the CEQA argument that, well, this isn't going to impact the great blue heron if the buffer zone is smaller. But because they have to comply with the Forest Practice Act, CAL FIRE has the luxury of insisting on it. We said it's 300 feet. That's a football field. We want our football field. We demand our football field. The plan submitter wouldn't agree to it, so we denied the plan, and it was appealed to the Board of Forestry. And the Board of Forestry did wind up upholding our denial of that plan. Another thing we do is assisting in defense of harvest documents and litigation. One example of this was a case involving the harvesting plan in Mendocino County. There were a lot of issues in the case, but eventually they all dropped out, and the only thing left was climate. And at that point, there was no case law, there was no forest practice tool, there was nothing that we had to look at climate change in a timber harvesting plan. But there were CEQA cases that said as much. So, we said, no, we have to look at this. And we did. Eventually, we did approve the plan, and it's very difficult because in climate change world, forestry is very different than, say a development under CEQA. Because in a development, you're looking at the vehicle miles traveled, that sort of thing. You're looking at the emissions that are going to be added to climate change. In the forestry world, you're really looking at, how is this forest going to operate as carbon sink after this harvest? So it's a little bit different than any other type of project you'll see under CEQA. And finally, we're also involved in enforcement. Again, we focus mostly on what we call non-dock cases. Those are cases where somebody just avoided the regulatory scheme entirely and didn't bother to get a timber harvest plan or a land. Unfortunately, one of the big drivers is cannabis grows. But the department has always been very adamant that we don't care what you're doing with the land. And our saying, we don't care if it's cannabis or corn. Probably about 4 years ago, I had the worst timberland conversion that I've ever dealt with, and it was for Christmas camp. So now I've updated the saying, it's we don't care whether it's cannabis, corn, or a Christmas camp. But this timberland conversion was awful. It was done at the worst possible time of the year, and it resulted in a lot of sedimentation of a stream that was 3 TB listed for sediment. Can you go to the next slide, please? So I'm kind of running out of time, so I'm going to jump through this. But the areas of growth in forestry, and Jane already touched on it, but climate change, climate change, climate change. Everything on this slide, I tried to break things out into different issues, but really everything on this slide follows from climate change. So it's been a huge driver of interest in forestry and also a lot of legislation around that. All right, next slide then. So, as far as resources for, and I forgot to mention on the slide before, other work opportunities in forestry include non-governmental organizations, a lot of environmental organizations that have an interest in forestry and frequently seek the department, honestly. And there's also other government organizations, including our partner agencies like CDFW. And finally, there are law firms that represent the real parties and interests in those challenges for harvest plans. That's the actual plans for companies. So as far as resources go, the CAL FIRE website and the State Board of Forestry and Fire Protection website are very good resources. Our agency partners, CFW, the water boards, California Geological Survey, Native American tribes, all have good information on forestry on private land. And of course, there's also the local non-governmental organizations. EPIC is an example of the Environmental Information Center. They are very hyper-focused on forestry issues in the North Coast of California. They're very good about it. They're very, generally very significant. But you also have the smaller organizations, and I always refer to them as the friends of the local water course name here. And those are the hyper-local ones. Those are basically the neighbors who don't want logging in their backyard, and they'll form an organization that purports to care about the local water course and fight it. Next slide. Oh, all right, that was it. Thank you.
Awesome. So I'll pick up here. Again, my name is Liz Esposito, and I am representing the private practice perspective. I'm a shareholder with the Brownstein law firm based in Sacramento. And I'll share, just before I dive into the substance here, to share a little bit about my background. So I came to the field of forestry and eventually forest law through a background, academic background. I've got my undergrad degree in forestry and natural resources. And after graduating with my forestry degree from Berkeley, I went on and I worked for the Forest Service. And at that point, I wasn't sure if I wanted to be a forester, maybe work with Toby at CAL FIRE, or I wanted to be a lawyer. So I had the opportunity to join the Forest Service as a NEPA planner, a National Environmental Policy Act planner. And in that capacity, I got to manage the NEPA process, collate specialist reports, turn them into NEPA documents, environmental impact statements, environmental assessments, manage the public comment process, and eventually on some of my projects, assist in preparation of administrative records for my projects that were litigated. So Susan Jane talked about the administrative record. And through that experience, just became really interested in the role of the courts and the role of lawyers in influencing forest management policy and what actually gets implemented on the ground. So I went back to school, went to UC Berkeley, got my law degree there in 2014. So I've been in practice for about 9 years now. I started out in private practice with my firm in 2014 with Brownstein, but had the opportunity to go back to government service for a couple of years from 2017 to 2019 when I worked for the USDA Office of the General Counsel in the regional office in San Francisco. And there, my portfolio included representing the Forest Service, so one of the USDA agencies within USDA, and my portfolio was natural resources. So laws like NEPA, the Endangered Species Act, Clean Water Act. So the laws, the alphabet soup that Susan Jane talked about. And now have been back with Brownstein for about 4 years. And I'll tell you a little bit about some of the clients that I work in private practice, but there's just a really wide variety of work that folks in private practice in the field of forestry can touch. And in private practice, the substance of the laws involves all of the federal and state laws that Susan Jane and Toby discussed. So I want to focus on some of the sample clients that I work with and tell you about some of the legal issues that I encounter. So the first type of client that a private practice attorney might represent are those in the forest products industry. And I personally represent both the very large entities in the forest products industry and very small. So an example of the very small would be nonprofit or community organizations that are working to bring community scale sawmill or biomass facilities online. And the idea is locate a facility in a community close to the source of materials that are coming out of the woods as part of forest restoration efforts. So typically these are small diameter trees and vegetation that don't have a lot of economic value, but if you can site a facility close enough to the source of the materials, the idea is to turn those materials into a product, whether it be firewood or posts and poles, or turn it into electricity, say through a biomass plant. Another example of a client might be landowners, right? So forest landowners, these are the folks that own and manage forest land. And to the extent they own private land here in California, they go through the regulatory process that Toby provided an introduction to. Then private practice attorneys might have clients that are trade associations, or they might be involved on behalf of their clients in a trade association. So an example here in California would be the California Forestry Association. And these organizations represent landowners and entities that are in the forest products industry. Some of my clients also include foresters. So here in California, foresters are licensed just like attorneys. And so I've got several clients that are foresters. They're consulting firms. They help landowners manage their land. They prepare timber harvest plans and other documents that Toby provided an introduction to. And attorneys might help foresters with a whole range of issues. They could be substantive with the underlying legal issues that the forester's client is grappling with, but it might also be business related. So related to forming business entities or to transactions involving the forester's business. I also represent local agencies. And so in California, this might, examples would include water districts. So there are water districts in California that are integrally involved in forest management projects in watersheds that feed the source of water that the districts serve to their customers. Also, agencies like resource conservation districts, which are engaged in helping landowners manage their land. And I also there's commonly a grant overlay. So a lot of times local agencies will obtain grant funding to either implement or help others implement forest restoration projects. And lawyers can be involved in assisting those public agencies that way. I also represent nonprofit groups. The groups that I represent as a private practice attorney are probably a little bit different than the types of nonprofit groups that Susan Jane represents. My nonprofit clients tend to be agency partners, so especially Forest Service partners. So these are agencies that partner with the Forest Service to basically increase the pace and scale of forest restoration work. So examples would be organizations that are engaged in conservation finance efforts. So a thumbnail sketch of what that looks like might be bringing private capital to fund and expand forest restoration work on national forest system lands, or nonprofit groups that are involved in technological solutions to forest management problems and partnering with agencies. I've got one client that works on NEPA, and are there ways through improving technology for environmental planning to expedite the NEPA planning process? So there's a lot of innovation going on with nonprofit groups that are seeking to assist the government in management of public and private lands. And then finally, another large category of private practice clients would be those that hold special use permits or that need other types of permission from government agencies to implement projects. So Marissa mentioned she works for utility companies, have a lot of vegetation management work, and can also require special use permits, say from the Forest Service, to the extent that they've got electric transmission or distribution infrastructure that crosses a national forest. Other examples that I work for are ski industry clients. So in California, a lot of our ski resorts are sited on Forest Service land that's managed by the Forest Service and that's operated pursuant to a special use permit by the ski resort company. I also have clients that hold cabin permits from the Forest Service. The Forest Service has a system of recreational residence permits. They're typically 20-year leases, and these are family cabins. And so clients can have issues associated with renewal or change of ownership that lawyers can help with. And then finally, just broad other types of infrastructure across public lands or that require permission from a regulatory agency. And the legal issues facing these clients are almost as broad, or at least as broad as the wide range of clients. So a lot of my work focuses on permitting and environmental review. And both Susan Jane and Toby talked about NEPA and CEQA and the California Forest Practice Act as a CEQA equivalent. We also are engaged in litigation. And Susan Jane talked about attorneys being on all sides of the V. And I think that's true in private practice. There are private practice attorneys that are on all sides of the V. So personally, in my practice, I'll talk about an example. One of my most recent federal cases, my clients tend to, if it's a federal case, tend to intervene on the side of the agency whose decision is subject to review in the case. But there are also attorneys in private practice that represent plaintiffs and that represent defendants. And then another big role for attorneys in forestry law and private practice would be corporate, so due diligence work, other transactional work. I'm not a real estate attorney, but I work with real estate attorneys and have colleagues that do real estate work for large industrial timberland owners. So acquisition and acquisition of large pieces of land. Also contracts and other business matters for folks in the timber industry or that are related. So just to sum it all up, I like pictures. These are pictures for one of my clients' projects, and this represents what I'm doing, regardless of the type of legal work that I'm doing for a client. In 95% of the cases, what I'm really, at the end of the day, on the ground helping the client achieve is getting from here, this picture on the left, to here, the picture on the right. So this, like I said, this is a client's project, and this involved, it's a project here in Northern California where I live and work. And this is a thinning project where the goal was to remove some of the smaller diameter material to open up the stand, make the stand more resilient to fire, wildfire, and insects and disease, and then ultimately to grow bigger trees, reduce the number of trees per acre there, and allow the remaining trees to get larger and create a more resilient and open forest condition. And then wanted to share also an example of recent litigation I worked on. So in this case, my firm represented a coalition of 14 amicus groups in a case captioned Forest Service employees for environmental ethics versus the U.S. Forest Service. This was a case that was filed in the district court for the District of Montana. So a federal case. It was filed last fall. And the plaintiffs in that case, so just stepping back, one of the Forest Service's roles is in responding to wildfire. So they have a wildfire suppression apparatus that responds to wildfire both with folks on the ground, and they have aerial support aircraft that in this case involved the application of aerial application of fire retardant. And what the plaintiffs challenged were those situations where the Forest Service discharged retardant from airplanes without a Clean Water Act permit, a NPDES permit under the Clean Water Act. In a very small percentage of cases, fire retardant, when it's discharged from airplanes, ends up in waters of the US. And the plaintiffs alleged that when that happened, that violated the Clean Water Act. And plaintiffs also asserted that the Forest Service should be enjoined, that the court should issue a nationwide injunction that prevented the Forest Service from continuing to drop fire retardant from airplanes until the permitting process that the Forest Service was undertaking with the US EPA was completed. And so on behalf of our clients, we wrote an amicus brief and advocated that the court not enjoin the Forest Service from deploying fire retardant during the 2.5 year permitting process that's now ongoing. And we raised on behalf of our clients in the amicus coalition just the important public safety and business concerns associated with the loss of forests to wildfire, and then the importance of the Forest Service and other agencies like CAL FIRE that respond to wildfires using this tool, the importance of them having that tool in the toolbox for responding to wildfires. And ultimately, the court earlier this summer issued the order that the court said that it would not enjoin the Forest Service's use of fire retardant. So the Forest Service is in a permitting process now with EPA, but it can continue to deploy fire retardant while that permitting process completes. And these are some pictures from my backyard just from yesterday. I had to update this slideshow because I think this just hits home, for me at least, why the work that we all do in this area matters. So this was the Harney fire, and these were taken from my backyard. This was a fire that CAL FIRE responded to yesterday in Jamestown, where I live. And they did a great job of responding quickly and getting the fire under control without any serious damage to property and no injuries. But one of the things I like best about this practice is that the work that we do matters. It matters because so many of us enjoy recreating in forests. We live next to forests. Even if we live in cities, the air we breathe is affected by forest management and wildfire management. And so it's important. And I think that Californians are recognizing that it increasingly, as especially in the last 5-10 years, as we've seen some pretty severe wildfire seasons here in California, how important forest management is to everyone in the state. So just want to wrap up now with a couple of notes on opportunities and resources. So a few areas of growth I'm seeing and that I'm excited about are in my practice are forest restoration, partnerships and collaboration, like Susan Jane mentioned. I think there's an increasing just attention to forest management by a lot of different groups. And folks are thinking about issues like wildfire risk mitigation, what we can do as communities to become more fire wise to improve our forest management. And then also I'm seeing a lot of innovative responses to meeting California's forest health challenges from my clients. And one of the cool things that I'm seeing is that my clients don't all have backgrounds like mine or, some of my friends that I went to forestry school with. They might have backgrounds in business or in finance or in technology. And they're realizing, that land management, forest management is so important to all Californians, and they're bringing their skills to bear in finance, in technology, to help solve the forest management and wildfire management problems that the state's experiencing. And there are roles, if you're interested in this field, both in firms and in-house. So, and I think we talked a bit about those roles can be legal or government relations, lobbying roles like Susan Jane mentioned. And then also pro bono. We didn't talk about pro bono yet today, but I've got several pro bono clients that are nonprofits that are engaged in land management issues. And I would encourage everyone, if you're interested in this field, to seek out pro bono opportunities with those nonprofit organizations or otherwise become involved with community organizations. And then last, just a few resources that have been helpful to me in my career so far in this field. The first we mentioned earlier, the ABA section of Environment, Energy, and Resources, the Forest Resources Committee. So Susan Jane and I both sit on the Forest Resources Committee, and it's an awesome community of practitioners in this field from all over the country. And it's pretty neat to hear about what everyone is up to, the issues that they're thinking about, that they're helping their clients with, and learn from others in that way. So definitely reach out to us if you're interested there. And then also conferences and seminars. Of course, there are legal opportunities. One of my favorite conferences is the Yosemite conference every fall that ELS puts on. And I've been excited the last several years. There have been panels on forestry and fiber management issues, which is great. But I also get a lot of value out of non-legal conferences and learning from non-legal practitioners and experts, both my clients and then just folks that are working in the field. So these examples of these would be opportunities that are hosted by universities or trade and professional organizations. So I mentioned one trade organization here in California, CalForest. They have an annual conference every spring. The Society of American Foresters is a national organization, and their annual conference is actually going to be here in Sacramento this fall. So these are just a couple of examples of opportunities that are non-legal in nature, but that are super helpful in just staying abreast of the latest issues and staying up to date. So with that, I'll turn it back over to Marissa for some other ways to get involved.
Sure. Thank you guys so much. So we have about 15 minutes left. I will, I'll just share a few things from my in-house perspective. And then while folks are gathering their questions, I'll just highlight some of the things on this slide about ways to get involved. So I think that Susan Jane, Toby, and Liz really shared a lot of information and hopefully piqued your guys' interest. I think you can see how the forestry legal practice touches a lot of different areas. And if you have background in environmental law, maybe you've done CEQA work or endangered species or kind of water law, all those different agencies and areas of law come to play. And then quite a few different clients. I think what Liz said about kind of people with different backgrounds and thinking about these things and the importance in day to day. So coming from just a law firm background, you know, you're working with lawyers all the time. Now that I'm in-house, it is kind of fun to see you've got, you know, here at Edison as a utility, we have arborists and foresters, and we're talking to CAL FIRE, where we have folks who are fully government relations lobbyists. And so people are interacting with different state agencies, CDFW, getting permits when we do a lot of wildfire mitigation. And so even if you are totally concrete jungle urban dweller, you know, getting the electricity to power your home and our cars and, you know, everything, it has to cross these remote areas, and you have to maintain clearance distances. And of course, when they do any of that work with different jurisdictions, they have to go through the planning process and get permissions and make sure they're doing it safely and protecting things like watersheds and endangered species. So it does impact, and it's kind of a neat area that you are able to interact with scientists and you know, folks who are getting dirty out on the ground, right? And a lot of different types of agency folks who are not necessarily lawyers, but there's a lot of legal issues that come up, and so you get to help think through it. So on this last slide, in terms of ways to get involved, thanks Liz for, you know, putting a plug into ABA, which has the SEER, the section of Environment, Energy, and Resources section, and then was really cool to find out both Susan Jane and Liz are involved with the Forest Resources Committee. So if you are particularly interested in forestry, definitely reach out to that group and get involved, learn what kind of programs they have. In terms of the California Lawyers Association, I mentioned you can join CLA. It's, you know, just like ABA, a voluntary bar association. There are a bunch of different sections. ELS, the environmental, new lawyers is for newer practitioners, but it doesn't matter if you're a, you know, immigration law, IP, criminal law, you know, all of those different things, tax law, trust and estates. There's a group for each of those. Definitely keep an eye out. A lot of these groups, they host webinars, one-offs. You can go to the conferences like Susan, Jane, and Liz mentioned. There's a lot of virtual things, but you know, the in-person events are back, which is nice. This 101 series is completely free. So we're not offering CLE credit, the continuing legal education, but it is free. And so there are also folks who may not be lawyers, or they work in a different area, and you know, say you're a contract business lawyer, but like you said, you have a client who wants to buy and sell something that touches on forestry. It's a good way to get a little taster. We have a lot of publications, definitely, you know, in the academic world, but also trade and bar associations will have articles and things. Our group in particular, the Environmental Law Section, for students and newer practitioners, there are a lot of fun things we sponsor. We have negotiation competitions on campus, writing competition. There's a mentorship program you can sign up for. You can get involved with legislation, so monitoring environmental legislation in, you know, Sacramento. We also do diversity inclusion summer fellowships, and then job boards. So I think everyone, Toby, Susan, Jane, Liz, all mentioned, you know, a lot of different ways you can work in this area. So there's definitely roles out there to get involved. Let us just wrap up. We've got 10 minutes and see what kind of Q&A we have. I see one that says, for all presenters, a combination of forest management history and the climate crisis is driving a wildfire crisis, which, yes, I think everyone here in California is aware. And our friends on the East Coast got a taste of it recently with the Canadian fires. Are current legal frameworks up to the job of doing the kind of vegetation management that is required to adapt? How are those exigencies impacting your jobs?
I'll take that one because I deal with that every single day. So this is a great question. It sort of depends on your feeling about things. I do think that although the public lands laws are complicated, complex, and often contradictory, there's still quite a bit of flexibility and discretion within that existing legal framework to conduct the kinds of forest restoration at scale that is required. So I don't think that it's the law that's a problem here. What I think it is more about is, until very recently, funding. But in addition to funding, training and staffing within at least the federal agencies. I can't speak to state agencies, so I'll leave that to Toby. But on the federal side of the equation, the land management agencies have been starved for funding for decades. And so they simply don't have the internal capacity that money brings to do the work that's required. We simply don't have the ologists or the NEPA planners or the workforce to get the work done within the federal agency. That said, as I mentioned in my presentation, Congress recently gave the Forest Service about $8 billion, billion with a B, of new money to do exactly this. What we're finding about that money is that there's a lot of money, but that doesn't mean that that translates to work. And so the agency has had a very, very difficult time, and the BLM is similar, to hiring people that actually want to do the work for the agencies that's required. So we had a funding problem. Now it's not really about money. It's about getting people and the right people in those seats to do the work. That's a human resources issue and also a cultural problem that in particular the Forest Service is suffering from. So I think that the law isn't the problem. It's really more about funding, training, and staffing and execution. And this is showing up every single day in my litigation, my policy, my collaboration work at every level. So it's a big issue that we're all confronting.
Yeah, and I would totally agree with that. You know, from the state side, we are a lot better off than the federal government. CAL FIRE is, the state legislature has really stepped up and been funding a lot of really good work, funding positions at CAL FIRE, giving us a lot of money to issue in grants to resource conservation districts and other organizations to do a lot of this work. But you know, ultimately, I agree that the problem is just the money and the resources more than the law. You know, it's just undoing these problems. It's a lot more complicated than, well, let's just let the fires burn. You know, unfortunately, we've got conditions where we can't just put fire on the ground and return these forests to the conditions they're supposed to be in, because we will wind up starting the very fires that we're trying to prevent, those stand replacing fires. So, you know, before you can start burning, you've got to start going in and doing the mechanical treatment, you know, limbing the trees up, cutting those smaller trees down, the ladder fuels, so that when you do have to put fire on the ground, you get that fire you want that burns off all of the under vegetation, but leaves larger fire resilient trees alone. So yeah, absolutely, I agree. It's money and resources are much more an impediment than the actual law. And as far as the law goes, California has been very dynamic recently. You know, just a couple of days ago, we announced the initiation of a prescribed fire liability fund, because that's one of the reasons why people don't want to put fire on the ground, is the potential that the fire escapes and they wind up holding the bag for damages. So the state of California is having a pilot project to provide liability protections, you know, basically an insurance fund that you can call on if you did, you know, if your prescribed fire met the criteria for this fund, then you can call on that fund to pay some of those damages that you might incur, because, you know, ultimately even the best planned prescribed fire can escape. So,
Liz, anything to add?
Yeah, I agree with what everyone has said. And I'll just note that also on the federal side, we have seen in recent years various efforts to streamline forest restoration projects. So that might include things like introduction of new CEs, categorical exclusions for certain types of forest and fuels management projects. So the idea there is to where the project fits within the category that project can proceed in a matter of months rather than a couple years or more, which I saw as a NEPA planner, just based on the factors that folks are talking about, staffing and lack of funding. I did work on projects, fuels reduction projects that took 2, 3, 4, sometimes even 5 years to get through the NEPA planning process. And I don't know that that's necessarily, like Susan Jane said, I don't know that that's a problem with the law, but perhaps a problem in implementation. And I think it's kind of I see it as an all hands on deck situation where there's no silver bullet solution, but there's a lot of potential solutions where I think working together, it's important to think about how we get the right projects done in the right time frame in the right areas.
Yeah, I'll just add on the collaboration front, and like you said, resourcing. I know that, the utilities, at least at Edison, we've been approached by forestry to join in some partnership agreements, stewardship agreements to work on restoration projects and kind of collaborate on the whole NEPA process. But kind of mixing the public and private funding and resources may be a way to move forward. And then mentioning the insurance aspect, Toby, yeah, absolutely. The scale and scope of kind of the amount of work that has to be done vegetation wise, particularly with climate change, is just grown exponentially. And then, the insurance costs for that are stratospheric. So people are looking at creative ways to kind of mitigate that. I think we'll let Toby end with the last question. Someone had a question about, is CAL FIRE actively partnering with tribes on traditional techniques? And if so, what does that partnership look like? And I'll just mention, someone asked about, accessing the links. The slides will be made and the video will be made available online. If you go to the CLA website, there's a dropdown from the Environmental Law Section with all of our past 101 webinars. So you can look at all of them. And we can also check if CLA and Pam, maybe for all the people who've registered or attended, we can probably send out the PDF of the slides. But Toby, tell us what's going on with Indigenous and Native tribe partnerships.
Yeah, absolutely. CAL FIRE is partnering more and more with tribes. That's something that we've been trying to focus on. And actually, we're currently hiring a deputy director for tribal affairs here at CAL FIRE for the first time ever. So we're really trying to improve those partnerships. But there's a very broad understanding here at CAL FIRE that there's a lot we can learn from the Native American tribes and their stewardship of the land pre-contact. So yes, absolutely. We have been partnering with the tribes. We assist them on cultural and prescribed burns, providing resources to make sure the fires don't escape. We provide a lot of grant money to tribes to do restoration work on their ancestral lands. So yeah, absolutely. Those partnerships exist, and they're only getting stronger.
Great. Well, thank you again. We're 1 minute over, but I appreciate everyone joining us. I think we got a lot of great information. And again, all the information will be available, and please reach out to any one of us with more questions.
Thanks, everyone.
Thanks, everyone.
Thank you.